for the list. Very urgent, then wait for some time.
Yes, sir.
Matter line, 24.
Yeah, it will appear automatically, fresh matters. Don't worry. Do not mention. But there are 60, 70 mentionings which are pending. Let us dispose of one after another.
It's already
We'll take
there in
up.
the list. Madam. My only difficulty is, madam, I have an annual contract. Madam. The X
Whatever we'll see to it. Let us see.
Got a stay, madam, behind my back.
Yes, just see. Yes.
3 months.
Right. Item number 1.
Come after 1 week. We'll see.
I only came to report today, madam, anytime.
Let us see, sir.
Item 1, sir.
What?
Number 1 members. It is permitted to file a counter affidavit within 1 week. Required money to be available of the department is available.
She is asking for release of fund. Or what?
But that is restricted question of 500 in the counter here.
What?
The petitioner is claiming certain amount which has not been dispersed to the petitioner, my lord. In the counter, we have explained.
Let us
She
see.
has completed.
Let the counter come. Let us see if we can grant interest to you at the hefty rate.
The petitioner has abandoned the work, my lord.
Sir, madam, let us see.
Let them find the counter.
For all the opposite parties. Or...
This one.
Yes. On the prayer of Ms. Das.
And this, they irrigation project?
Would you like to file rejoinder?
Yes, my lord.
Rejoinder within a week? If any, 2 weeks.
Item number 2.
Madam, Annex 13.
Hmm?
I'm challenging the Annex 13.
Hmm.
So also the speaking order. Regarding penalty for non-supply of cancellation of purchase.
Which one you are assailing, sir? First, be sure. Which you want to assail?
I'm assailing the Annex 13.
Annex 13.
My lord.
So let us see Annex 13 first.
Page 54.
Yes.
It's regarding the penalty of non-supply and
Forfeiture of the performance security amount.
My lord. The
Non-supply.
case- My lord.
Yes.
The case like this, that my lord, I am the successful bidder. As per the purchase order, I supplied the medicine to the opposite party number 2, the Odisha State Medical Corporation. And without testing the product, the medicine to the laboratory, they have misbranded, reason being the caps are variation.
What?
The caps. This is a syrup, my lord.
Yes.
This is the vitamin B complex
Spur-
syrup.
They
Yes.
thought it
Caps
is
are
spurious.
variation.
They thought it is spurious.
My lord.
There was any testing, laboratory
No, my
testing?
lord.
So,
Notice.
Item number 3.
My lord, my senior is appearing in the Odisha State Council Corporation.
Odisha Medicine Medical Council. State Medical.
With whom? You can't appear.
My lord, my M.S.RAMAN, Mr. Barik is appearing, my associate. Earlier I was a counsel. Therefore, he is saying.
You are in the panel.
Yes. My office is in the panel, my lord. I no longer,
Office can't be the panel.
my office is that, my lord, as a counsel. Otherwise, he can take the notes.
You are a senior advocate. You can't plead. You can't file wakalatnama. You can't do it.
I cannot, my lord. I
Then why you say my office? That's so the tacit way of running an office by a senior advocate. No. Against the Advocates Act.
my associate's name only I was telling.
Waves.
2 and 3. Mr. Narayan Bari.
Appears and waives the service of notice. Copy may serve in course of this day next week.
Item number 3.
Lord, may I humbly pray this matter to come along with another PIL 28046 of 2024.
Why?
Matter is identical, my lord, relating to the SCB Medical College, that kidney transplantation unit, my lord. So in that matter, there is a notice which has already been issued.
Back with that.
28046 of 2024.
Yes.
Item number 4.
May please, Your Worship. My lord, I had already filed that the English translation copy, but it is not.
Flag E or what?
Sands,
Initial.
auction of sands, relating to the sands. That will be the process. Approximately the full river to Roxanne kindly see Alex Rupan. The advertisement.
Just 1 minute.
Yes.
Yes. This is over. This was a episode of 2020.
Yes.
So now we are in 2025.
My grievance is that even after expiry of this minor, the auction bidder who is allowed to minor to continue after that. That is my sole grievance with the process.
How can it be? Has it been adjusted when the bid was opened or in pursuant to this?
No, see, he was selected. Opposite party number.
So this bid,
He was
this-
allotted the work. But after completion of 2005, minor to 5 years, he is again allowed to continue without having.
How? renewal clause is there.
No, there is no renewal.
Mr. Mahapatra, is it that during Corona he was not allowed and thereafter, sometime thereafter,
No,
he was executed with agreement from there 5 years?
in the
It is not like-
2021, minor the agreement was executed. I have given that minor.
So 5 years will expire 6. If 21 is given, then 5 years will expire in 26. How?
Sometimes.
I have taken a stand, you also may kindly see page 38.
So the difficulty is kindly visualize. You are talking about a particular date I have seen.
My-
And immediately, I think on the same day or a later day, the entire shutdown was declared.
This is 2020.
I understand,
Yes,
sir. 20th March. I
Hmm.
think it was 21st March or a 26th March. 24th March, it was declared.
In the
Complete shutdown.
in the writ application.
Then-
Even after-
So, 15
No, no.
March.
Then from the date of the execution of the lease, 5 years.
Ground is a different way, ma'am. My ground is after taking that lease, ma'am. It has not worked for 3 years. As it is evident from the district survey report, also may kindly see page 38. I have given the district survey report, which is minor published on 2/11/2000.
Annexure,
Annexure minor 3, district survey report of Khordha district.
yes.
But your lordship will get at page 38.
Sir, we are not concerned with that. We are concerned with when the lease was executed.
In the year 2021, years,
21. So that was for a period of 5 years.
5 years.
So they are doing it.
If my lord, he will not work for 1 year, for 6 months, then it is liable to be cancelled, my lord. That
So
is the-
now this is what action has to be taken by them. Now they have not taken any actions.
They have-
Now
Maybe
whatever. So they will not permit beyond 5 years. Whether he has excavated the sand for 2 years, but he is pay the entire royalty for
No,
the whole
it has
5
been
years.
paid. That is also my grievance.
That is.
Kindly see page 38.
File your affidavit. That is what is there. File your affidavit. 3 weeks or 3 weeks, come. Nothing more than that. 3 weeks. Rejoinder, if any, 1 week after 4 weeks.
What is his grievance? 2020, that lapses in 25. That may be possibility that the agreement is.
From the date of a lease
Lease
agreement,
agreement, that is
5 years. If they have executed after 1 year, then from there, 5
We have to
years.
take instruction and say, well, my lord, that is.
Go, file. Call the next.
Item number 5.
I had tried one eye, my lord.
What are you?
I may not to allow.
Then we are rejecting. Would you like the rejection of your?
Yes, sir. No, I am not present.
Item 5.
Yes.
My lord, ma'am. Need to.
Please, your lordship. State person takes execution as a last chance.
Yes, sir. Yes, who is for the state?
This is
DSJ.
We are appealing
Oh,
for
Union
the-
of India. Yes,
Yes.
Mister.
Well, in this case, last occasion, my lord, the connecting case, my lord, as a very pertinent question to the land counsel for the petitioner, that about the maintainability and the prayer made thereon is not sustainable in the eye of law. Reason being that they have employed different parties and we have received an instruction for a particular organization that is DGR. The DGR also not a authority to decide the regulation as regard to getting all sort of benefits to the army officials. As regard DUPT party is concerned. The DUPT also the circular is not conscious to the provision laid down on the circular itself because it is a fifth pay commission they have referred to. Now seventh pay comes come to force. So that's why the last occasion my lord directed the other case counter affidavit. If lordship wants, then in this case also will file the counter affidavit.
This is a different case. I think Honorable DSG, what is submitting is about item 38. This is item 5. It's about deputation only.
I think the ex-army man, there is already a quota in many of the civil services.
Yes, my lord is correct. Yes.
They are allowed to participate.
Lordship, I think for
In the open competition, yes.
recruitment.
Yes.
External induction is of two types for army personnel. One is direct recruitment, another is in deputation. This present case is about.
Are you still in service?
Yes, Your Lordship. I'll be retiring on 31st January of 2020.
Then it is not maintainable.
In the
my
last
lord.
year of
Premature
service.
stage is coming.
Then can a deputation be done for such a short period?
That is what 1986 memorandum was.
That even for a shorter period, less than 1 year, the deputation post can be given.
Yes, Your Lordship. That was the memorandum that sorted for 1 year. I'll be if I am observed on deputation, then I'll be continuing on re-employment. So Lordship may kindly refer Annexure 4, page 86. My case is exactly on the implementation of this office memorandum. On the basis of a parliamentary
Just.
para to me.
This is office memorandum of 1st May 1986.
Yes, Your Lord.
Just wait. It is within 1 year, it is there. What is your reaction to this? Annexure
My
4?
lord, let's make
Has
the
it been
last line.
superseded subsequently by any office memorandum?
First, may I just the last line, my lord?
Yes.
Just list last one. Given deputation from up to the date on which they are due for release from the armed services,
Correct.
then thereafter maybe continue the re-employment.
Correct.
If there should be on the deputation basis, then that case within a 1 year can consider re-employment.
No. That he may be transferred on a deputation post if he's going to retire within 1 year.
My
And
lord.
if so transferred, then in
Yes.
that event, he may be allowed to continue as a re-employment. This is what the DOPT really says about it.
Yes.
Now, really, we
Thereafter,
wanted to
he has
know
also circulated given
whether
instruction on
any
the-
this office memorandum is of 1986.
It's
Now nearly 49 years, I think 39 years have elapsed.
my lord.
Has this office memorandum been superseded? I just
That
want to
instruction,
know.
that instruction I didn't have, my.
What is
I'm
this?
putting instruction.
Because it is of a 39, nearly 40
Yes,
years.
it's a long back, yes, long back.
It's a long back. Now
Yes.
many things might have come in between.
And definitely.
So I just wanted to know from you.
So plus you may give some time, then I have to take instruction from them.
Then you file your affidavit.
Yes, ma'am.
Fine. 2 weeks. Rather 3 weeks, 1 week, 4 weeks.
I'll give you 4 weeks, ma'am. 4.
No, 3 weeks, 1 week for rejoinder and 4
Yes,
weeks.
ma'am, fine. Yes,
Yes.
oblige, ma'am, oblige.
This must have another route.
That is what.
Because this is amendment. The original.
No, original is there. This is not an amendment. It says that by suitably amending. So that was the 40 years before. Now, what has happened? The scenario has changed.
This was on the basis of a parliamentary estimate committee report.
There, the parliament sits at least thrice or 4 times in a year. What happened 40 years before you were talking about? Let us see if it is still stands. No difficulty. If it is superseded, let them disclose the stand. No difficulty.
Item number 6.
My pleasure, Lordship. My lord, I may be permitted to withdraw with the liberty to file a paper.
Why?
The rate of interest imposed to the petitioner has been wrongly mentioned and the prayer portion is to be modified.
Make an amendment.
Any additional document you want to file?
No.
No,
What?
only amendment.
No.
Other-
So file an amendment that it has been wrongly stated. What is the rate of interest? I do not find.
24% that has been wrongly mentioned as fact.
Where? In the prayer portion, I do not find.
But it's not in the prayer portion, in the petition, my lordship.
Which portion? Which portion?
Page 7, para 5.
Synopsis.
Synopsis is not a part of the pleading, sir.
Okay, page 7, para 5.
It's not verified or affirmed.
You have stated 24%.
34 I have seen 10 plus 24 in that ground.
Page 8 also, third line. 24%.
There's 7, my lord, so 34%, 10 plus 24.
Yes, I have seen that you have said in ground number paragraph 15 Roman 1. The page 16 first line.
Page 10, para 8 also the same.
Same.
Yeah,
So what is the difference?
We'll file the amendment petition.
Yes, the counsel for the petitioner leave to application for amendment of the pleading. This is the matter. Yes, sir.
Let's,
Be brief, be concise.
Lordship, kindly, only Lordship, kindly see, as though I have given all the documents, Lordship, and I have brought Lordship, the entire copy of the second copy with me, Lordship, entire bunch of documents.
You sought for a lease deed to be declared as void.
Lordship. But that matter, Lordship, can I remember that matter, Lordship, I filed a very critical affidavit, and I have filed a detailed affidavit. So for appeal provision there, Lordship, on the remand, Lordship, the appeal has been dismissed on the ground of limitations. That matter, Lordship. Lordship, can you have a glance to my today's affidavit?
Yes.
Lordship, only 2 to 3 paragraphs I will read, Lordship.
Now the copy has been served.
Yes, Lordship. Just now, I am serving just now. Yes, you.
Let her go through it.
Lordship,
Monday. Let her go through. Yes, she has a right to peruse a copy of the, what is this? Additional affidavit.
Additional affidavit, Lordship.
A copy of the additional, sorry, the
Item number 8.
It's 2 weeks. Next.
Item 9.
Yes.
Item 9C.
But here the issue was we got the technical glitch in dropping of my tender.
That you could not.
Yes.
Have you identified from NIC? Have you identified? Yes.
Yes, I have obtained instruction. Lordship may kindly. Lordship may. Over the page, your Lordship may see.
Reverse the page or?
Reverse it. Reverse. In view of the above, it is to state that. Your Lordship
What
find
is
that-
this? Oh, yes.
Yes. These are the 2 clauses which were mentioned in the tender document. Now, if your Lordship may.
So you wanted to shirk your responsibility.
No, ma'am, but that was there in the tender document. That is a separate issue, ma'am. Your Lordship may kindly have the paragraph thereafter. It is further stated that on 28/7/2025, a total number of, this is 12 bidder, it is written, it is in fact participated in the online tender and submitted their technical bid. Out of these 7 bidders, successfully uploaded both the financial instruments and bid documents between 3/24 to 5/24 on the same day through the e-procurement portal. The petitioner has claimed that although he attempted to submit the tender fee so and so, the system did not acknowledge the transaction and it failed despite the amount being deducted from his account. The petitioner has further stated that his technical bid submission was only partial. However, it is to mention process in the procurement system is time stamped as per so and so clause.
Sir, we have seen that you are shirked the responsibility, sir.
Apart from
You are saying, you have admitted that somebody wanted to do it, you accepted the money, but it was not uploaded and it was a failure. He has shown that there was a failure.
because
And you say that he should come well ahead. Why he will come on a last date?
these bids, online bids are conducted by the National Informatics Center. And in a similar case, this honorable Lordship may kindly have a glance to this judgment. So also this judgment has been upheld before the honorable apex court. That you will also be.
By simply rejecting the special petition or by,
Special petition is a different, but this honorable courts.
no, you say affirmed by the Supreme Court, that's why I am asking.
No, they have, initially some interim orders were passed, then subsequently, the matter was taken on board and the SLP has been rejected. So Lordship may kindly. Thanks, Your Honor. And in that judgment also, they have referred to the Maharashtra.
Whether,
Social
whether
Development-
this,
Uh,
whether this IP address from where he was attempting,
Yes.
that there was some technical glitch in that IP address or not?
But that
That
can
will-
only be
I
explained by
think,
the National Informatics Center, to whom he has also imputed that. Because they can.
have you seen the judgment and you are relying? This judgment talks about the things that up to 3 p.m., 122 bidders could successfully upload their offer. And it says that there was some technical glitch. The court disbelieved the story on a preponderance of probability that what he's saying is wrong. Here is a case where you have not been able to demonstrate that on a particular day or a time, whether any bid was uploaded, you have not been able. You would simply say that the timeline was given. You ought to have come one ahead. Why will come at the last on the last day?
My lord, we have said that in between the 13 bidders participated for this particular tender, and out of 13 bidders, my lord, 7 bidders during that time period between which the petitioner has submitted his bid.
That is not coming from you.
But that is the instruction, your lordship may kindly.
Please read the instructions.
Your lordship
I have, maybe I am wrong in understanding it.
Your lordship.
In view of the above, it is to state, as per section 7, clause 1.2 of RPF, in the event of any failure, malfunction or breakdown, the electronic tender will not. Now, it is further stated
Yes.
that on 28/7/25, a total number of 12 bidders
Yes.
participated in the
That is in
online
fact
tender.
13 bidders. That is wrong.
Please, and submitted their technical bid.
Yes.
Out of these, 7 bidders successfully uploaded both the financial and bid documents between 3:24
On the same.
to 5:24 on the same day through e-portal. The petitioner has claimed that although he attempted to submit the tender fees at 3 the system did not acknowledge the transfer, despite the amount being deducted from his account.
This is what my lord. The 7 bidders, they have successfully done it. So far as, and in between that time period, that 3:24.
The money being
Why-
deducted is not disputed.
Money being deducted, then.
That-
And
That is
And
not
that
the
too,
reason.
and that too at 3:25.
3:20.
And the last timing was 5:50,
5:30.
5:30.
5:30.
5:30, because you have said 5:24. That's why I said it can't be.
No, my lord, within 5:30 is the last time.
That is what I say,
This-
not 5.
Not 5. But these bidders, these 7 bidders, they submitted their bid in between 3:24 p.m. to 5:24 p.m.
File your affidavit.
Yes.
Let us see. Let them file. This judgment is there. Can't be.
And they have also referred to the another Supreme Court
Yes.
judgment of Sampurji
To
Pilonji.
Sapurji Palanji is another. I am conscious of that,
Right.
but the facts are a bit
Let him
different.
file.
File your affidavit.
And in the meantime, if
2 or 3.
I may only suggest, subject to my lord's acceptance, he has also implicated the National Informator as a.
I know the notice has to be given.
So let them also produce that, if
The notice has not gone to them.
not known.
So we are issuing a notice and permitting you to file your opposition within 2 weeks.
Right.
Yes. After
There are two words mentioned. First one is the present writ petition. Another is 21190. Given the number on the last date, it did not come up today. If that day it can be taken up 21996 of 2000.
Yes, next.
Item This writ petition, Your Lordship, is challenging an assessment order passed by the assessing officer.
Yes.
Our submission is, Your Lordships, a division bench of this court has held that if an audit is done, report is to be given within 7 days, and is not, the whole audit assessment is invalid. Division bench of court and subsequently
Can you
consistent.
not go to the appellate forum?
Lordship.
Can you not go to the appellate forum to agitate this point? These are the points you can agitate.
Our submission, Your Lordship.
Yes. Yes.
Our submission, Lordship, this is contrary to law laid down by this court, and the assessment is beyond jurisdiction. That's the reason. Otherwise, I would have gone in appeal. That is the reason, Lordship. Because division bench thrice has held that these assessments are invalid, and
You have come against appellate order.
Lord, I come again. I went in appeal earlier. Appellate authority remanded it back. Assessing officer now says yes. Division
Fresh
bench is
assessment is done by virtue of fresh assessment is done by virtue of remand order by the appellate authority.
Lordship, yes. Lordship, yes.
Now this time you bypassed the appellate authority and wanted to come directly to us.
No, the reason is this, Your Lordship. Your Lordship decision is there, and it limitates the question of jurisdiction. Your Lordship, that is.
And then, let us accept this proposition that there is a direct judgment of the Honorable Supreme Court on a point, and then bypassing the appellate authority and High Court, one can approach straight away to the Supreme Court saying your judgments are very clear, so decide the matter on that point.
No, I'm not on that, Lordship. I'm not saying.
Can you bypass? Yes.
The submission is, Lordship, assessment is barred by limitation, it's barred by jurisdiction. Question of jurisdiction, 226 is maintainable, Your Lordship.
Sir, I understand it. When you went to the appellate authority on an earlier occasion,
Lordship, yes.
and the entire proceeding was relegated to the assessing officer to reconsider,
Lordship.
that was taken before the appellate authority. Whether the remand order speaks of consideration of this point as well.
I will show that, Your Lordship. I'm on a slightly different point. What Your Lordship, Honorable Lordship is asking me is, why not in appeal? Why the luxury of writ petition? That's the first point.
If you say that it can be, then why not you approach the appellate authority?
Our submission
also.
No, the submission is slightly different, Your Lordships. Since it is beyond jurisdiction, writ is maintainable, alternatively
I
not
understand, but it is writ is maintainable, but whether entertainable is a big issue.
On entertainability, Your Lordships have held that when it is barred.
It is a discretionary powers of the writ court whether to entertain or not to entertain. The court may refuse if there is an alternative efficacious remedy. If you can challenge or raise this point before the appellate authority, can
Lordship, my lord, the Chief Justice is
from one
so much
judgment. I am just reminding you of all. From one
Your Lordship, no. Your
This,
Lordship knows the law. I'm not going to contest on that, Your Lordship. Your Lordship has so much rich experience. What I submit is slightly different. Your Lordships have consistently held when assessment is barred by limitation and wins without jurisdiction, writ is entertainable. We will not invoke
Oh, there
alternate
is-
remedy. Alternate remedy will not be invoked.
no,
That's
it
what
is,
Your Lordship-
I know, but anyhow, it's a
When it
discussion
flies-
more.
What I want to place, Your Lordship, is there is one division bench, no, 3 division bench judgments, and it is jurisdiction, time limitation, and not on any other point. I want to independently tell Your Lordship, these are supplied to Indian Oil Corporation, and Government of Orissa specifically said, when Indian Oil Corporation is set up, we want to grant exemption. That's a different matter. That's on merits of the matter.
Next, please. So, to the three.
Understand.
Lordship, any tips to me also, Your Lordships?
Sir, I have seen the order of the appellate authority at page 153.
Lordship, I am grateful, Lordship. I just want to say, Lordship. That's what I wanted.
And you acquiesce to this order. You
Lordship,
acquiesce to this order because by that time it was already a time bar and the de novo exercise could not have been initiated. You could have challenged this particular order, but you accepted.
I may read page 153, Your Lordship. That, Your Lordship,
Yes.
I will
And
now
then
satisfy-
155, I have seen 5 and 1.
Lordship, yes. Yeah, I just want Your Lordship to read 153 first.
No.
Can I read it now, Lordship, with Your Lordship's permission? Page 153. 2-3 minutes only, Your Lordship, then I leave it to Your Lordships.
Indeed, 7 pages, Your Lordship.
Your Lordship.
Yes.
May I read from page 152 bottom, Your Lordships?
Yes.
My Lord, this is just. However, from the above discussion is evident the completion of assessment made in the present case.
One page
152, last para, Lordship.
or 52. Sorry.
152. I'm grateful.
Yes.
I'm grateful, my
Yes,
Lords.
yes.
However, from the above discussion, it is evident that the completion of assessment made in the present case under section 43 of the Orissa VAT Act is not as per provisions of law laid. Further, it is accordingly held in the absence of completion of assessment under section 39, 40, 42, and 44. Reassessment under section 43 of the Orissa VAT Act is not sustainable and cannot be initiated.
Correct.
Hence, this forum feels assessment in this case should have been completed under section 42 and not under section 43 after the receipt of audit visit report by assessing authority.
Correct.
From the above observation of facts, it is pertinent to note the statement given by the learned advocate and the question raised were vital. Actually, erred in completing the procedure section 43 instead of 42 of the Act. This forum set aside the complete assessment proceeding as not completed the assessment proceedings under the correct section provisions of law. AI is directed to issue form 306 to complete the procedure 142 of the OAT within a period of 4 months. Applicant is directed to cooperate with the assessing authority, provide audit books. So as far as
that is why it is say. Now you say that even under section 42, the time has lapsed.
that contention I raised before the AA also, the appellate authority said, please raise it before the AO. Now, that the submission, therefore, Your Lordship is, Your Lordships always discourage parties to approach higher forum at the interlocutory stage. Supreme Court said, Privy Council, Your Lordships all the same.
No, that's true. That's true.
Therefore, Your Lordship, I did not rush to Your Lordship at the
That's
interlocutory
not an
stage.
interlocutory stage, sir.
In that sense,
This was a disposal of an appeal, finally, with certain observations which have a cascading effect.
Lordship. No, observation
So far
was
as the
this.
SSC is concerned.
The observation is this. From the above observation, in fact, is pertinent to note statement by an advocate and
No, I
question is a
appreciate.
vital.
Had the appellate authority stopped, that the entire proceeding was undertaken by the assessing authority invoking section 43, though it could have been done under section 42. So it's a wrong exercise of the jurisdiction in the past and hereby set aside. Had he stopped there, no problem.
Lordship.
But he
He-
went further.
He went
Granted
for that.
liberty
Huh.
to proceed to initiate a proceeding under section 42.
Lordship, yes. Two questions, Your Lordship. I'm grateful
You
to
could
Your
have
Lordship.
come against this order.
I didn't rush Your Lordship because if I succeed under 42 before the AO, I need not come before Your Lordships. So, Your Lordship, I cannot be Your Lordship. What's up by not what the assessing appellate authority has held? Your Lordships kindly see. I'm grateful to Your Lordship. This mood is a little lighter than 2 minutes earlier. But what I am submitting for Your Lordship is the appellate authority says the observation of the advocate about 42 also is vital. He did not say 42 is valid. And he couldn't have said in the teeth of the Lordship judgment. But whether 42, he doesn't know what 7 days report is there, etc. Therefore, Your Lordship, that is one part. The second part of it, Your Lordships, kindly see series of judgments right from the Privy Council. Your Lordships have taken the view. Against the remand order, party need not go to appeal at the higher forum at every stage. If the matter is concluded against you, then you can challenge. That's what Your Lordships have held. Therefore, Your Lordship, I just...
But now the judgment is accept the order of remand.
At this, when they after the remand,
He can challenge it, but accept the order of remand.
I'm grateful to the Lordship.
Question that after the remand, I participated and submitted to the jurisdiction. The order of remand appears to be faulty one.
Lordship. No, Lordship, that's
That
what
you can't.
Lordship. I'll satisfy Your Lordship on that. That I have to satisfy Your Lordship. That's what I want. Lordship. Yeah. Lordship, I can proceed. If the revenue wants to file a reply, Your Lordship, I'm in Lord's hands. Otherwise, I can satisfy Your Lordship here and now, just now.
This was, it has not been admitted, Judge. Your Lordship.
No, I don't know.
What?
Lordship. I handed over a compilation of judgments to my...
No. The assessing authority has not decided as yet.
He has passed an order against me. I
That
am
is
challenging
what is
that. Your Lordship.
there. Yes.
He has passed.
That is what that's a very open when the order is passed. It's very open.
After the first appellate authority passed the order which Your Lordship saw at page 153, the assessing authority has passed the impugned order. I am challenging that.
No, I understand.
Your Lordship, yes.
My brother was referring some other page, that's why.
I'm grateful. I'm grateful to Lordship. I'm grateful to my Lordship.
This may not be admitted, Your Lordship. What happened? It is the second round.
I will show Your Lordship.
With great respect to my Lord Senior, Your Lordship. At the first occasion, the assessment was completed, Your Lordship. Against the assessment order, the petitioner has come to this honorable court by filing a writ petition, Your Lordship. And that writ petition order is at page 107 and 108. Your Lordship, in that case, all these grounds have been taken, and this honorable court has not interfered and relegated the matter to the appeal, Your Lordship. Before the appellate authority has...
No. Did they challenge the order of remand before this court?
No.
No.
So what was the writ petition?
That remand order has not been challenged.
Oh, I am asking, you are referring page 107.
Assessment.
Original assessment without going to the appellate authority.
Yes.
So they raised those points.
Yes.
But this court did not interfere and relegate him to go to the appeal. The appellate authority reversed the order and remanded the...
This is the remand assessment.
Yes.
But the petitioner challenged both the remand assessment order as well as the...
But the difficulty was,
2020.
now what he says is that at those point of time, it was an assessment done under section 43 of the OVIT Act.
Yes.
He was always saying that the 43 has been wrongly invoked. The assessment cannot be done in actual matrix. It cannot be done under section 43.
It has been accepted by
the appellate authority has accepted. Yes, the entire exercise was faulty one.
Yeah.
It cannot be done under section 43.
Yeah.
At best, it can be done under section 42.
Great.
This is what the appellate authority. Now he says that issue of press notice. That is the form, the GST or something form. And thereafter you proceed under section 42 and bring it within a time frame. So this is what he now says, that even 42, this exercise, because of the limitations put forth in the said section to invoke that provision has also lapsed. So there cannot be any adjudication under section 42, if I correctly understand his argument.
Lordship have articulate much better than me. I'm grateful to my lords.
So this is what now he says. So you can't now, first and foremost question which I understood from him, that if the statute forecloses the door whether the court by an order can open such door. In other words, if the jurisdiction is not vested into a court, whether by virtue of a judicial order can the jurisdiction be vested,
Your Lordship.
even by a Supreme Court?
Your Lordship. 49(2), section 49.
That's what that Antule's case was, Your Lordship.
Your
Remember,
Lordship,
was
section
an,
49(2).
A.R. Antule's case was that only.
That Act 49.
That is the remarkable judgment of Ramdas Srinivas Nayak versus A.R. Antule.
Lordship, yes, that is exactly it. Because it's
Section
court held,
49(2).
High Court order, you cannot do.
Section
Yes.
49(2) of the that Act. Your Lordship.
Yes.
Applies only to tribunal and High Court. order.
Your Lordship, first appellate authority
Yeah.
is also a court, my lord.
No.
On the last occasion, I have argued in one case, and my lord, the Honorable Chief Justice has accepted that by looking into the CPC. And Your Lordship, some of the judgments are also there. The first, Your Lordship, but Your Lordship, that part, Your Lordship, but where any court, Your Lordship, 49(2), where any court or tribunal passes an order in appeal.
Where you are 49? 2.
Subsection 2.
Okay. Yes.
Where any court or tribunal passes an order in appeal or revision to the effect that any tax assessed under this act or the Central Sales Tax Act should have been assessed under the provision of law other than that under which it was assessed. Your Lordship, we are 43 and 42. Then, in consequence of such order, or to give effect to the finding or direction contained in such order, that on over any part thereof as relates to the assessment may be assessed or reassessed, as the case may be, to tax at any time within 5 years from the date of such order, notwithstanding the applicability of any period of limitation to such assessment or reassessment under this Act. So my respectful submission before Your Lordship is that, pursuant to the remand order of the first appellate authority, this particular assessment has been done, Your Lordship, which is appealable and which are factual disputes are there. So the jurisdictional limitation, Your Lordship, this covers, and within this period it has been completed, Your Lordship. So for that,
Mr. Thompson, after undertaking 43 assessment, can you go back to section 42 assessment? That is
Your Lordship,
our High Court judgment.
no, Your
I
Lordship,
was appealing.
Your Lordship, what
I was
happened?
appealing.
What the department now?
Balaji Tobacco.
Let me clarify the department's thought. Let me clarify, Your Lordship, being I am an officer of the court. Let me clarify. What happened? There was a audit under section 41.
whether it has, the appellate authority has a trapping of a court or a tribunal.
Your Lordship,
Under the OVAT Act.
Your Lordship, let it be Monday on this point.
Sure.
Your Lordship.
That's the only section 49(2) can be invoked by you because it comes, if it comes under 49(2) as it appears,
Yeah.
the two things have to be done. Whether the appellate authority the appellate authority has a trapping of a court or a trapping of a tribunal.
Yeah.
Tribunal is defined.
Your Lordship.
The court is not defined.
Your Lordship.
Appellate authority is defined under section 77.
Mal.
In that event, tell us from the functions of the appellate authority, the powers of the appellate authority, that it has a trapping of a court.
Your Lordship.
And if the words are defined in a statute in a particular manner, even if the word is of a wide import, yet the court will give a restricted meaning because it is appearing defined in the statute
Your
itself.
Lordship. In fact,
So that's a very fundamental principles of interpretation.
Some income tax cases.
No,
So
you have to come and say that 49(2) only in two situations,
Your Lordship.
the court or the tribunal.
Your Lordship.
Whether the appellate authorities has a trapping. Counsel,
Yes, Your Lordship.
you also ponder upon these issues and tell us.
One more point I want on this. I'm grateful to the Lords. This very point has been considered by Supreme Court in Muralidhar Bhagavan Das in income tax, which my learned friend is specifically saying a direction is to fall in a provision of this should be direction necessary for discourse of the appeal. Where the appellate authority writes extra sentences, that will not, my Lord says, Subar of judgment will show that. Plus, an appellate commissioner will not be a court within the meaning of this section. That also
Yes,
is
that's
covered by
all.
Supreme Court.
So that's all.
Only that part.
So we are keeping it on Monday to be taken up as a first matter.
So far as your Lordship.
42
Mal.
does not stand alone unless it is accompanied by a process.
Let me clarify.
That is,
1 minute.
we are on a more, Mr. Vishnu, we are on a more fundamental issues.
My Lord.
Fundamental issues.
Let me answer.
We are simply on a fundamental issues. First thing is that whether the appellate authority can confer a jurisdiction, can waive off the other limitation or inhibitions which are there in the statute is the first question. Second, you are taking shelter under section 49(2).
Yeah.
Then the very opening sentence says if a court or a tribunal passes any order, then in that event within 5 years you are bound to implement the order.
Your Lordship.
Now, appellate authority's order can have some kind of a flavor of an order of a court or a tribunal. That's the first question. We have to.
Mal. That.
We will not go into the other nuances, which is touching upon the merit. We are not going into that.
My Lord's.
Your Lordships, your Lordship.
Yes. At an hour 14.
Proceeding initiated of 26, my Lord, without service of demand order, my Lord. And in Annexure 5, they said that the order is not available, man. The last occasion have taken time for the instruction.
You are not disputing.
I'm afraid that just when he told that he will attend in this case, she was also
You know what?
in this case, last time I had to issued an intimation, which is on case number 23. The system was changed to ITD to ITBA. So once processing was done under 133(1)(a), and a demand was created, the Lordship. There were a lot of demands, a small demand he has paid. And regarding this demand of 24 lakhs something.
The intimation order
Right.
is supported by some reason.
Right.
So where is that reason? That's what he wants.
It is appealable.
You want the reason
Yes,
for this demand.
yes. One what
For the reasoned order, you require copy of that.
Yes,
It is not served on you.
yes,
You have to use that.
yes.
So they say that it is old demand, they cannot retrieve
Right.
it. So then,
My lord, before initiation proceedings, my lord, already 133 notice has been initiated. My lord, from 2017, one circular has been changed, department changed.
he want the reason for his demand. Change of software, will it obliterate or efface
Providing a reason that.
a huge demand to 24 lakhs and all.
Where is that,
He
where is
started
that
proposal
demand,
to-
where is the demand dated 10/1/2013?
That was not communicated.
They have not communicated.
Yes, that is communicated. Were communicated that all. Now they have initiated it in attachment proceeding. Thereafter it came to his knowledge, my lord. And there are certain demands. The small amounts were paid by the assessor and asking for this intimation for appeal. Since it is appealable. I want to make up.
Why you are not providing them a reason?
Software.
All are lost. How? And that point of time, it was all manual.
The manner.
Well,
So you must have a manual records.
Till recovery is complete.
right.
It seems the assessment records are permanent in nature.
Why you are not providing?
What is the age of preservation?
20 years.
20 years.
20 years.
20 years.
20 years. So 20 years is not lapsed.
And
20
the
years
fees of the company provided.
or finalization of dispute. 20 years or finalization of dispute.
What to do? We'll have to. That's his right.
Is also required. Also,
What?
not appeal, my lord.
Why appeal?
Now, how can he file appeal? Mr. Sir, how can he appeal without the reason? Reason, he has right to reason. And gets the reason and if it is plausible, he may not appeal. If the reasons are absurd, then he may appeal.
I have already delivered at least here also many judgments, there also many judgments on a right to reason.
That is one of the facets of principles in appeal justice also.
How can one file an appeal only on the basis of one that there was a demand to the extent of such and such, and hereby this amount is attached? They do not know what is the reason. How they will file an appeal?
Such a not the demand. Understood still.
No, against that demand, how can he challenge that without knowing that what are the difficulties, what are the wrong which is given, this finding is wrong.
Kindly allow one chance to let me take the instruction.
What
Whether
instructions?
Physical copy is available in the department.
It has to be, when the rule says that it has to be preserved till 20th year, 20 years. Secondly, till the entire thing is finalized or order is passed, then how can you avoid it?
Presently, there is no option to download the old intimation order. So the intimation order cannot be provided to you.
And the order passed without any communication, whether it is a good order in the eye of law, I'm just talking. Those line of judgments which says that the orders passed but kept in a cupboard, never communicated, or in a drawer. Then, sir, what to do? What instruction? Don't proceed for recovery. Have you attached?
Yes, my lord, attachment of the next one is the attachment of.
When they have done, that is the 24.
Yes,
Come on Tuesday, file it, because it's a long back. It has been done. So if they waited for such a long time, they give for 3-4 days more. Come on Tuesday. Come on Tuesday. The pivotal issue raised in the instant writ petition.
May I please, Your Lordship? Item 15, Your Lordship.
Yes.
Date for
This item was listed day before yesterday.
Yes,
Covered
you
order
have
was
cited-
also.
You have cited a wrong decision.
Uh,
You have cited the decision which was already disposed of. We have been asking you that the issue of section 168A is pending. You said yes. But you have referred to this WPC 952 of 2025 that is already disposed of. Okay.
I'll submit the correct order, Your Lordship, in course of the day, if that's okay.
No. This has already been disposed of. When it is disposed of, then why you are also not? You are concurring it. You are concurring with it. You are signing it.
RD engineering.
You have also.
This is the. This
No, Your Lordship has asked me. I have seen that order. In that RD engineering has been said.
print and media, the
Your Lordship, that is a different order. Because my knowledge senior on that day argued the case, different cases were there. In some cases, he has given this judgment, and in some cases, but I have seen.
This has already been disposed of. Judgment. Madam, you appeared in that matter.
No, Your Lordship, actually my senior was arguing the matter which was
What are you
listed day
talking?
before
Your name
yesterday.
is appearing.
Miss Janesh, 952/2025, you are appearing.
Yes, Your
and
Lordship, in that.
You knew that that case was disposed of, and we have been asking the standing councils whether this is 168A. Mr. Madhav Rao said yes, that is 168A, and you considered. What is this? We trust and believe you, and we sign it without looking at it. Perchance it has come to my notice. Hence, I have to be very careful. Each and every order I have to see. I will not trust.
Why you have signed it?
Where is Mr. Madhav?
He's on his legs. Actually, he's having personal.
He has
And look at the last order. to be tagged with 952. 952 has already been disposed of. She appeared for the petitioner.
The entire challenge is in perspective of section 168A, that is extension of force majeure clause.
That order, Your Lordship, that order was in mistake. The order in 14,941 was a mistaken order. Your Lordship, there was an error apparent on the piece of paper.
Then why you signed it? Why it was signed?
This first page, first paragraph, RD engineering is the lead case.
But look at the last paragraph.
Your Lordship, absolutely.
So
Sir, please see this.
Your Lordship,
Please see this.
952.
Your Lordship,
Ms. Janish was appearing.
Your Lordship.
No, we should dismiss the petition. On that
Sorry,
ground.
Your Lordship.
No, we are going to dismiss.
Let it come.
Come up late.
Sorry.
Assessment.
Your Lordship, let it come tomorrow, Your Lordship.
No, we are recording certain observations on the role
Your
of
Lordship, I'm
the
unable to.
members of the
I'm
bar.
unable to start my
We are
video.
making certain observations on that.
Sorry, Your Lordship. Actually, I was not that day arguing the matter, and I've got my baby
Madam,
crying.
when you submitted that particular order and the countersigned by both the sides, saying that yes, the matter is still pending before this court, and we believe that the matter is pending. Later on, we find that the matter has already been disposed of.
Actually, Your Lordship, what has happened?
No,
My wife was arguing the matter, and
No,
I
madam.
didn't know what
No,
order
madam.
he has given. I'll file the correct order, Your Lordship. In
no,
course
we
of
are
the
going
day.
to dismiss. We are going to dismiss on that score.
Your Lordship, one chance may be given.
No,
I'll
no,
file the correct order.
we will make the observations. We'll make the observations. That what should be the role of the member of the bar.
This will hamper the case, Your Lordship. I don't
No,
think
no,
so.
whatever. Why, if you do not, if you want to play tricks with the court, then we are the last person to.
No,
accept
Your
it.
Lordship, it is not tricks by
No,
mistake.
it's definitely you are taking a court for a ride.
No, Your
Sorry,
Lordship. Maybe by
we
mistake it has
we
been
don't
submitted,
know.
Your Lordship.
Sorry.
There were certain matters listed together, so maybe must have been some fault. I'll make the corrections, Your Lordship. This may be
No,
given
definitely
one
not.
chance.
We will not believe anyone. There will not be any concept of a covered case. Henceforth, will not.
One chance may be given, Your Lordship. There were certain matters listed together, so maybe there must have been a mix and match. I'll file the correct order, Your Lordship, if that may be allowed.
No, it is not.
Or
It
let
is
this
not.
matter be
It is
listed
not.
tomorrow, Your Lordship.
It is
I'll
not
argue it again.
appreciated. It is not appreciated. At least I am the person who will not appreciate this. Definitely not.
There must have been a mix match, Your Lordship. If one chance may be given, I'll rectify it.
No.
This may give a lesson to everybody. Your Lordship.
Absolutely. You are also at fault.
I've been asking you also, both of you.
Your Lordship, by looking into the past.
Every time,
the engineer-
whosoever gives a covered case, I ask you also whether that is covered or not.
Your Lordship, my one friend has.
After verifying only, we are
Looking the
just asking them to correct the order and give it.
Henceforth,
This is not
Your
you.
Lordship,
This is not you.
It's unpardonable. It's unpardonable. Can't be.
Good faith also.
What is a good faith?
We have lost
It's
our
a-
good faith.
No, definitely is a non-application of mind, or in other words, wanted to take advantage of the courts, that the point which is urged in the petition is pending adjudication by the court. So this matter should also be tagged with that matter. We believe the members of, but it appears that matter is already disposed of. Why it will be a tagging? This is not expected.
That's true. This is the order of 2024. No pleading is there.
In that case
I have
also,
verified the pleading. They have not said why they have come late. They have not prepared appeal. Appeal is for
in
them.
that case
They have
also,
not-
we have to file
no
a
pleading is there.
modification. In that case also, we have to file a modification, because in that case also, this wrong has been.
Has come to my notice, so I brought to brother's notice.
No, sir.
Yes.
This time. Also. Okay.
That to 21/8/2024 order. Now he comes forward that is barred by limitation and challenging 168A and furnishing a wrong order. This is the manner in which the bar proceeds, and you are accepting those as covered case.
This is not expected.
So personally, I report to all the.
So it is impossible for us to.
No.
check
Sometimes
each
we
and every-
believe the statement made at the bar that the matter is still pending. There is this point is to be decided. So we just believe it and then fix and tag this matter along with the other matters so that at one go the entire matter can be decided. And if it appears that that matter was already disposed of, this is not a way to treat the court. And there is no mechanism to find out whether it is done. I'm really thankful my brother, at least he come across with this.
By looking into the past page, let's see how that's.
You have pressed where also. How do you expect?
Past page, you know, by looking at the past
We
page,
can
the
keep track
lead-
of each and every case which is disposed of by us or any other bench. It is the bar who has to come forward. This much assistance we expect from you.
Luckily, we did not sign the order.
you know, so something.
Unmerited. Nothing has been spelled out. Unmerited. Yes.
Yeah.
Item number 16.
Apologies, your lordship, is this.
In capital of the CST Act, in fact, certain relevant documents like the SOFA notices and the replies have inadvertently not been brought to record mirror. I pray one it's time to go out these documents and record.
You want adjournment?
Additional affidavit to disclose the other relevant documents. 1 week.
Item 17.
Yeah, this matter relates to cancellation of registration for all the.
Now we need not have to believe that.
I have it is relevant to time.
You have just seen the episode earlier. Give the first thing, look at the prayer and then restore the registration.
This cancellation was made in 2023.
Yes, please.
So, are you not aware section 30 has been amended?
Yes.
So how do you justify your actions?
Because currently.
Have you stated in your description why have you come late?
No.
So
Section 30 also has outer limit. Section 107 also has outer limit. Beyond that, you have come up without describing anything or disclosing anything in your writ petition with regard to delay. This was perhaps during the corona period, we have been condoning on their acceptance. And then
Make out a case, you have not made out a case.
Plus then MLS I'll permitted to withdraw MLS I'll file a better application.
Fine, withdraw, give a memo.
There is one case where the cancellation is of the year 2020.
Which one? Show us. Which one?
I will take a recourse of section 30.
No bills.
Then you have alternative remedy.
MLS I'll file better application with the
No. This, if this is the recurring feature, we will not. Nice. Like cancellation is don't file returns.
Item 18.
No, this is regarding non-constitutional PSC application. Yes.
What is the question?
Where is the order? By the attendant authority?
Yes, minutes. Annexed 2 minutes.
Constitutional case, sorry, appellate tribunal.
Yes.
Yes.
What's the book of it? You don't know whether the order of the appellate authority is annexed. or-
That's it. Minutes. Annexed 2, page 20.
First find out whether it is there or not.
Within time, yes, sir.
Annexed 2.
Proceed by.
Yes. Now we will make a stupid, we will not go in this one.
First, previous days, evening, if you wish, you can give them, they will set it up. Then we
19.
will back. So we will record their computation.
Item number 19.
Yes, in this matter, Manoj, the petitioner challenges the ex parte remand order, Manoj, along with the rectification rejection order. Manoj. Whereas in the for the period 2020-2021, the opposite party raised a demand
under section 73 of the GST.
there any provision for an appeal against the order rejecting the rectification?
Well, I subsequently approached the rectification.
What is there?
Your Lordship,
107.
Well, it's legal.
Against
161
order also.
Your Lord, now it became a new trend, Your Lordship. When the original order became delayed, then 161 filed and against 161 they have approached this honorable. And on the last occasion, Your Lordship, so far as the personal opportunity of hearing, what is his argument on pleadings? And Your Lordship was, I have argued, and Your Lordship
Let them go on the section 1 in those.
and recently Honorable Madras High Court Division Bench taken the same view what Your Lordship on such rectification. If there will be rectification, then personal hearing is required.
Let them go. Let them go.
Recently, on
Whereas I
14th July,
whereas in this case,
that
whereas
part
I have,
provided.
Let them go to the update of
Your
it.
Lordship,
whereas I have already voluntarily reversed my ITC malus. That is the only ground.
multiple opportunity has been granted in the assessment.
No malus, only one opportunity has given malus in the show cause notice malus. Plus the ground of raising of demand is overstatement of ITC. This for the period 2020-21.
That's our view. We have taken the section.
Because there is a bank attachment malus since very long.
They're going to raise that when the alternative revenue is there, then we go there.
The same interpretation what my Lord Honorable Chief Justice
Order
appealed.
delays like this.
Yes.
Your Lordship has said the same thing on such rectification. So when there is no rectification, no adverse.
Absolutely.
Absolutely.
Next.
Item 20.
It's been vast. So,
Sorry, I'm sorry. That to be called at 2 p.m. Item 20 will be at 2 p.m. sir. Item 21.
Please, my lord. My lord, this appeal is constructed more not on the ground of propriety or legality of the order passed by the Honorable Civil Judge. It's more concerned in the concept of justice. Your Lordship. That is, if the ratio decided by this Honorable Court is not uniformly used, applied, then jurisprudence becomes a casualty. Your Lordship.
here this is
Madam. Madam.
doctrine of stare decision.
Madam. The case is that granting it, the salary of the petitioner was stopped after 32 years of service without conducting any proceeding or lordship.
That's where things are difficult. That's the only order is which is the order 23rd of June. Is nothing which has been decided. This interlocutory order. Nothing has been decided.
That's what my humble submission. That in invoking 7D of the Odisha.
Can we bypass the adjudication by the single bench and decide ourselves?
No matter.
Para 3 of that order. Include the action taken under the miscellaneous and subject of an accommodation.
No, that I have seen already. That's why I'm asking the interim order is there. And why the appellate court will substitute its finding.
My humble submission is.
Yes.
The court had set the ratio under 7D. The granting aid, that means the salary of an individual employee cannot be withdrawn. And using that particular judgment, a relief has been granted by the Honorable Single Judge on day one. On submission of this particular ratio, the granting aid withdrawal has been set aside in other cases. I just prayed for a stay because if my salary is stopped at 58 years of, I'm suffering severely a lot. That is only I prayed stay in reference to those judgments that similar ratio has been decided and it has been used It has been applied in one case to grant a relief, and I'm similarly situated, similar prayer. I'm just praying for a stay, but that was not granted. That is my simple submission. My lord,
Everything understand, but let him go on there because the application is still there. It has to be heard. You can review your prayer when they appear on an application. The court will definitely.
my lord, may at least grant me that. Even that I will make
The already the instant appeal arises from an order dated 23/6/2025 passed by the single way. That in your.
no, I apologize for that because
Then you should also face the consequences for that.
my lord, that subsequent development took place after I filed the petition. After I filed the petition.
Sir, question is that after this order of 23/6/2025, you
Right.
were challenging in the
Right.
another idea was filed.
Right.
Which idea was disposed of
Right.
with certain.
Right.
You have not disclosed that fact, you noted.
I apologize for my reason, but my reason, my lord, I have enclosed that entire document with the writ petition. There is no submission, suppression of facts because all the documents have.
Then what according to you, let me understand the law. Then what according to you would be a suppression of facts and would it not be a suppression of? Let us have the distinction. Divisor.
As I understand, my lord, I would finish as I understand. My limited prayer in this writ appeal was to bring to your lordship's kind notice that a ratio has been decided, and
I am asking on a suppression.
That is what I'm hearing in my way. My understanding was that I am to appear before your lordship to bring to your lordship's notice that a ratio has been decided by this honorable court, which has been used, which has been applied in one case and has been denied in my case. That was my simple understanding with which I filed this writ appeal. After that, after I filed this writ petition along with this particular IA, where this order was passed, after that, the opposite party one of the opposite parties passed another order saying that you cannot come to the institution, your services are terminated. So that I brought to the kind knowledge of the court by filing an IA because I needed to bring that document to the kind knowledge of the court. So therefore, that order is a and this is what I am challenging. That this is what I have challenged. And
But
so far as
this order-
not mine.
This order of 23-6
Mine.
has a reference in this. That has a reference also.
Mine. Honorable Single Judge has made a reference to this IA in the other IA. That is there.
Order.
My lord, that is there.
So
What my lordships are, lords are, that I am not suppressing a fact because I have enclosed the entire document, including all the IAs and the orders. Therefore, there is no suppression of my side in that sense. Since I am limiting my prayer to this particular aspect of the order, that's why I remained there. It's not, I didn't, because even suppressing that, I will not get any benefit. Disclosing that also is not going to help my cause. That's why it is not any intentional way of suppressing, because I have already enclosed all the documents. There is no such intention to mislead the court by suppressing, because that is, I won't get any benefit or any.
Sir, 23-6-2025.
My lord.
10230.
My. That's why it's not any willful suppression because it didn't have any. That was a separate cause of action. I was prevented from coming to the college. That's why I brought to the knowledge of the honorable court. Here, the challenge part is this part. My very humble submission, very limited submission is that my salary has been stopped without any proceeding, your lordship. And this court has held that this cannot be done. It is prima facie an illegal order. And the Honorable Single Judge has appreciated this fact and quashed the withdrawal order in another case. And I just prayed for a stay so that my salary keep continuing so long as the adjudication is there, so that I survive. That's the limited prayer.
Resolution is already made. This court can. And let us fight. We are in let us battle, sir. We are not in ordinary appeal.
So
kindly one sentence, if I may, my lord, we kindly have a look at page number 126, my lord. Just Honorable adjudicating a similar matter, exactly identical matter, where the granted order has granted the salary had been stopped by withdrawal of a granted order. The Honorable Single Judge at paragraph 4 is contending that it is contended that by Mr. Rath, learned senior counsel, that the orders at Annexure 15 and 16 were issued taking recourse to the provisions contained under 7D of the Odisha Education Act 1969. It is contended that the power of issuance of notice relying on Section 7D of the Odisha Education Act was the subject matter before this court in WPC 1845 of 2020. The previous judgment I have enclosed.
This court-wide judgment dated 27/2/2023 has already held that taking recourse to the provisions contained under 7D, withdrawal of granted aid in respect of a particular employee cannot be made. It can only be made in respect of institution. My lord, on that submission, the Honorable Single Judge has quashed that order.
Recently, a trend has developed in filing
because he is already suffering because the salary has been stopped. My lord, that particular point, when I tried to convince my lord that it was not related to this particular order, that's why I didn't make a sentence. But the entire petition and everything has been reinforced. My lord, kindly consider at least.
That's my consistent view all throughout. And I can't deviate unless I am convinced to deviate.
My lord, that is what is my humble prayer that
Now,
secure lordships pardon my. And I failed to inform your lordships that the IA that your lordships held that appraised was actually filed after I filed this rate appeal, your lords. That is the only point I wanted to make sure. Should notice that IA and the order was passed after I filed this rate appeal. That was. And that's what I failed to inform in my submission. That's it. And the IA order was passed after the rate appeal was filed. Like.
If your lordship is not put to inconvenience, item number 22. If your lordship is not put to inconvenience, item number 22, since your lordship has specifically fixed this matter, item number 20.
my brother is.
I apologize, my lord. That's where I failed mentioning before your lordship that if your lordship allow me, I will file the amendment.
He has been very moderate.
No, my lord.
He has requested me something.
My lord. My lord. God bless.
Item 2. I have a small request that item number 22, since your lordship has fixed a specific matter today at 2 p.m. So can I pray, this is a regularization matter of the bank, can it be taken up tomorrow? I pray for tomorrow. If it is not
We
taken
do
up.
not know. When there are many lawyers appearing in one case, there is every possibility and chance of
The case collapsing.
collapse of the list.
If it is not, then I pray for this.
Item 36 manner, on admission matter manner, taken after the right of this court.
Matter fixed for.
Item 15 manner. So. The order was. My lord, the case is pending, my lord, before the court. Stated that, as well as the other earlier cut which has been.
The rest of
Yes.
those say pending.
And the last paragraph which has been, the last paragraph.
Soon, this disposal of order.
My lord, the last paragraph, I do not know how that number has come.
You do not know who will verify.
Sir,
That bench will verify.
no, sorry, that each and every number which has been mentioned, I have to check it, that is. But the 168 orders are, judgment cases are pending.
That they particularly asked you. And you have said yes. Other side also I have asked. They have also considered. Then while signing the order, I could find that the case was disposed of.
That case is pending and before 168 cases are pending. I do not, sir, I do not know how that case number has been mentioned in the order, that is a
Sir,
correct.
you are relying on an order and you do not know that what is the reflection of a case. Do I believe it to be true?
Sir, this
That you will read only the one portion of the order and will forget the other portion.
I am sorry.
Sorry, that can't.
And you have corrected it and they gave it to the bench.
What
You
that,
have
because
corrected it and gave it to the bench.
that is already, my lord, both the cases are pending and.
Now we have disposed of matter, the order will follow.
Is it, but
The order will follow.
there is.
Item number 20.
that Order, that typical error has been
Yes,
made.
sir.
here in the
Item
order.
20.
So that is the reason I have.
It's not a case of a typographical error. Anyhow, you have done. It's called
Item number 20, fixed for 2 p.m.
24/7/2025, in course of the hearing, they have given one table, my lord.
Why should I take?
Is that read appeal number?
Who is a lead arguing counsel? You are a lead arguing counsel in 20.
Yes, 394 of 2025.
Which one?
394 of 2025.
Fine. Yes, ma'am.
This is not your.
Lord,
Not your.
appeal they have filed, my lord, against the writ petition filed by me.
So let them argue first. They are the appellate. When you are attacking their right.
No, my lord. Last occasion, they have given one table. Your lordship said, as against 65 vacancies.
He said that you can go and verify the records which they have holding.
That we have already verified.
Let them argue on that.
On merit, my lord.
They will definitely argue on merit.
Yes, let them.
Which one should I take?
407.
407.
7.
Yes.
So far as merits is concerned with regard to the application of that reservation policy is concerned, learned signature was perfectly right. I do not want to argue and take further time on the matter. While applying that reservation policy, they have vertically created one more category which was not permissible. The signature was right. Therefore, the entire exercise what has been done at that point of time, I don't justify it at the point of time. So now what remains is now how many of these petitioners could make it by notionally creating or making a proper selection process. Now kindly see at page number 47, the operative portion of it.
Yes, operative portion.
Of the direction. At para 26. In Roman. Para Roman 5, para 26.
See that. Fresh recruitment exercise.
Yes, fresh recruitment exercise, that is one. Next, in para 27, this said process shall be conducted without displacing or jeopardizing the appointments of ex-servicemen who are erroneously appointed by the opposite party against the post. No problem, because already they have been appointed. They are our employees. We do not want to say anything about it. They are also not here. Such appointments of the ex-servicemen shall be regularized by creating supernumerary force. This absolutely, I don't think so. Find anything creating supernumerary force for the ex-servicemen who have been regularized. They have been appointed. The petitioners upon their appointment pursuant to this order shall be accorded seniority over those ex-servicemen occupying supernumerary posts.
So your remark is that there cannot be any concept of a supernumerary post to be
Yes,
created.
yes, number one. Number two, fresh recruitment process, that is also not possible and permissible. And
No, it is not a process, it is an exercise.
No.
The exercise means that you have to reopen.
yes, that's notional.
You reopen the entire panel, evaluate the suitability and the eligibility of the
Correct.
candidate. And then,
If that is to be construed, we have done that and that table.
and then appointment, they have directed the appointment to be made.
Yes.
Whether they come or they do not come.
Yes.
That's where their grievance is.
Sure.
That if they do not come within the zone, then why should they? So their contention is that if they are taken out of that particular vacancy which you advertise,
Yes.
then the entire vacancy becomes open.
Yes.
And then everybody has to be adjusted within that particular entire vacancy.
Yes.
And these persons would be kept outside, may I use the word, the cadre position. they are being really in an ex-cadre position.
Yeah.
And therefore, this is to be done.
Yes.
Where you say that this cannot be, because they have already occupied these particular sizable numbers of the advertised vacancies.
Yes.
Sanctioned vacancies. And whatever is left out,
Yes.
if they come, they can be considered.
Yes, even by assuming that certain things are flawed with the previous selection process, but they have to qualify by virtue of their merit, by notionally doing that particular exercise, which has been said in the first para, to be construed as it is a fresh recruitment exercise. Even then they have to qualify by virtue of merit. If they don't qualify, even then, by that time also in 2012 also they would not have made it. Had we done it properly, let us take that we have done the proper recruitment process by doing the reservation horizontally, then also they would not have made it. That is the. So they can't seek relief which they would not have got at that point of time. No. Therefore, notionally we have done. Notionally, the entire exercise now the second time also has been done. Earlier we said that in the post which have been built up, the cut-off mark we pointed out, only 2 would qualify. Then thereafter, as directed by the Honorable Court, we have done the fresh exercise by notionally taking all the vacancies and the posts which have been left out. Even for that also we have made this particular exercise, and at the most now 3 would have made it by assuming that they. Otherwise, their cut-off marks are much far below. They can't make it at all.
And in this rate petition, who was the rate petitioner?
This Chinmay Prasad. Yes.
Does he come within the purview?
No. Can you have take the table only 3 altogether in all the petitions? Last time I gave that one table.
No, I'm just because then I have to weed out. I'm
Yes.
just trying to weed out.
Yes.
Those rate petitioners who are
In which petition?
coming within that zone.
Yes.
At least they will not have any remarks.
Yes. Just give us the extra table.
And those who are still out
Yes.
or kept out of this, then they
In one candidate in writ appeal 401, that Antariksh Jha will make it in the fresh revised one out of 3. One is Antariksh Jha. He is one of the petitioners.
who is representing him. You are the sole rate petitioner there. Yes. You were the sole rate petitioner. Yes. So at least
Only one petitioner.
their appeal in this regard is taken care of.
Yes. Then in the writ appeal number 425, one Manoj Ranjan Kuntia. 400, how many are
Who is
there?
representing the rate petitioner there?
Only one.
Mr. Dhara
Only one.
Mr. Dhara Sahu.
You told it's only one. Only one, right?
Yes.
Only one in that appeal. In third one, 406. There is a one person, Suvendu Kumar Patra. He is also only one. I think these 3 writ appeals. The responsible
Can be. They're taking WA 400, 401, then
406.
406.
Yes.
Now, these rate petitioners, they do not qualify.
They do not qualify by hypothetically or notionally making a proper selection process as on 2012.
Yeah, none of them are coming from. That is why it says that in those repeats, there was a single registration in us in found. So there's no difficulty. Rate appeals can be segregated. This actually. Yes.
So this is on the aspect without you are touching anything on merits by conceding that single judge was right. And number 2, going back to the proper selection process notionally in 2012. They would make.
Who is it 407?
I'm representing 8 and my friend representing 3.
How the writ petitions can be
Read
segregated?
petitions, read appeal.
They were the writ petitioners together. Composite writ petition was filed.
Yes.
Now, in an appeal, can you segregate the writ petitioners?
It was my duty to, since my learned friend said I am nothing from P, so I had to.
How can it be?
Let my brother argue in this case. In other cases, I am also active.
Yes.
My learned senior, he has, as far as the appeal is concerned, he has admitted that they have done a mistake. But as far as accommodating the while doing that re-exercise, they have accommodated 3 petitioners up to 31.5 they have taken, 39.5 they have taken. The last occasion also there was a observation from the Honorable Court. There are 65 posts they have agreed in the counter affidavit that lying vacant. And in this chart they have given, they also admit that they have 58 posts, and they are from 58 posts, and they are accommodating 3, which your lordship has now observed. So I would say that on merits, since they succumb to the merits, and as far as the accommodating for the first exercise, while the writ petition was admitted, there was a stay as far as general category is concerned.
What was the stay?
Any appointment to the general category will be subject to result of the writ. So when there was this, that the interest of the candidates were preserved. So when there are ample number of posts are available, and they admit that they have done a mistake, and the persons who have not come up before this honorable court, they may be as treated as they have not, that word is
persons sleeping in
bench, I don't remember that word.
bench sitter.
Bench sitters. Bench sitters. The persons who have approached this honorable court, and they say somebody has somebody have failed, but how they have failed, they have not clarified, because when a person has appeared in the written exam and he has called for the interview, now how did they declare them as failed? That is also a question to be.
Why not? If they do not qualify in the interview also, of the aggregate marks, sum total of the written and the interview, if they could not secure the requisite marks, then why not?
That is one part. They have 3 persons have failed out of this 11, and 8 persons are still remaining. So,
but they do not come within the zone of appointment according to the.
Yes, that I am trying to impress upon your lordships. They have considered the 31.5 as the last candidate in the zone of consideration as far as regular. 31.5 is the last mark, cutoff mark they have considered for selecting the CSM people. 31.5, the general category. I am talking about the total. So if they are saying that 31.5 is the last person, and they have the requisite number of posts available with them, and so many of them are also been in the meantime some have left and some have maybe someone has them given to higher post, but as they have considered the 31.5 as the cutoff mark, so says as far as this my prayer would be, they should consider as well since there was a stay of this honorable for the stay type of admission.
No, what they are saying,
they should consider 31.5.
They say that the total number of vacancy advertised, if it is taken together, then in the applicant, it would come to this
39.5.
182nd rank. It should come to 182nd rank. And 182nd rank there has been a tie between many from 173. So all are taken together. Then in that event also the cutoff marks would be 139.5. If it is a cut marks of 39.5, then these three persons really comes within the zone because they secure more than 39.5 or 1% 39.5.
That is their value.
And it's every petitioners here they secured lesser marks.
But most of them secure more than the cutoff mark they have cut off for the ESM candidates. That is 31.5. Most of the some petitioners also be that I will conclude only by saying that my friends what they
That is what is the difficult.
and we would pray that let all the candidates be taken up because they have posts and they have 10 years in the meter. Let all the petitioners be considered. They have posts.
We have already indicated that you are candidate remarks have been given.
That will be only the I would say.
So they say that total number of posts was 158.
Millions.
And the non-ESM posts were 190. And then they were supposed to be filled, but they actually 84 UR candidates were offered an
appointment. 74 ESM.
And the 61 UR joined. So there was also some gap. So they say that then we have calculated those posts and then the 182nd second rank could come to 39%. And 3 of them are coming, so we are appointing.
No, if they apply, yes, they have said it in a different way. Out of 158, 24.5, they
The question being an answer is that the first thing is the supernumerary post concept. The Margaret Singh just said that take an example of this 158 post or 119 post, whatever.
Yes.
As it appears to me, the observation of the single was that this post of 158 or 119 should be treated as the vacant post for the purpose of filling up. Whatever has been included in those posts, they will be excluded from the purchase numbers, and a supernumerary post would be created, means a separate, a parallel, I would say a parallel way of creating a particular post.
Yes.
Unsanctioned.
Unsanctioned.
And then you fill up this 158 or 119 in accordance with law.
That's what
this is what I perceived the direction.
Yes.
What I have to say, because they say, how can it be a supernumerary post where it's not essential? So if they are taken into consideration, there are certain features left where we can fit in whatever comes.
But they admit their mistakes.
True. Now the question is how to rectify and what are the modalities to rectify. The learned judge also says that you will not displace them. You will not disengage them. Means you cannot discontinue the services.
That can be rectified. That can be rectified, and all the person can get the benefit justice if provided they will accept the same. For a moment, kind of
petition is there are certain hard realities. If they wanted 158 persons in your category, if we create a supernumerary post and then fill up 158 candidate new, that means suppose if they have filled up this one, if 61 post or something, I don't know, if 61 joined, So actually, the 61 surplus persons are also kept there.
But we are not saying, not saying that supernumerary post be created. Your Lordship, one chart I have given your Lordship, kindly see the for a moment. One chart I have given to their table, reply to their table. What they have said, I am accepting. What they are saying, they have suggested or given, I have accepted. Your Lordship, kindly see. Clarification in reference to information supplied by.
Given it to them?
Yes.
Yes.
In reference to information supplied by the MCL on 24/7/2025. But this table they have given on 24/7. According to their table, my lord, your lordship may kindly see total post advertised 303.
Yes.
Your lordship,
Yes.
on reserve 158, OBC 12% 36, SC 16% 43, ST 22% 66. Total post is 303.
Yes.
Then joined and cleared 238. Remained on-field vacancy 65. They have indicated in their chart below. Then your lordship may kindly come below that. On-field vacancies as per category wise below.
Where do I get it? The last set.
Remained on-field vacancy below. They have indicated below.
Where, which?
Your lordship may.
In your share chart.
Yes. Yes, below.
Where do I get it?
Your lordship may kindly come to for finding against the offer of appointment ESM. Your lordship may kindly see below. Not only that, my lord, your lordship, my lord, may kindly see my lord's order, my lord. Better, your lordship has taken note of that. Order dated 25/6.
No, I just.
My
Can you expect a man to recollect
No,
facts? You have to recapitulate it. Just remind us.
Your lordship's order dated 25/6/2025 taken note of all the amendments and indicated the learned counsel for the respective writ petitioners uniformly submits that out of 303 vacancies for which advertisement was made, appellate 65 posts remained unfilled. Your lordship has already observed that in that order dated 25/6. Then, remained unfilled vacancies 65. Against your category, your lordship may kindly see. Against your category, 150 out of 158, 114 have been joined, and 44 vacancies are there. According to them, your lordship may kindly see. They have indicated table, last table. Towards last right side, minus 44 they have indicated. Minus 44. That means 44% did not join. Six tables are there, my lord. Last table, yes, last table 44, my lord.
Yes.
Minus 44 they have indicated. That means 4% did not join, my lord. Then against OBC category 36, actually joined 28, and vacant post is 8, my lord. Against SC category 43, joined 37, remained unfilled 6. Against ST category 66, joined 59, remained vacant 7. According to them, and total 65% are the unfilled vacancies are there.
Yes.
So, kindly turn to I belongs to OBC category. So, lordship may kindly come to next page. In the event unreserved posts are filled up, the cutoff mark on merit will reduce to 39.5 mark up to rank of 182. They have indicated below. They have indicated in there just below cutoff mark.
No. Yes, that is gone. Yes.
In such situation, based on the merit, 17 OBC selectees will move from OBC category to the UR category. The leave 70 OBC selected as below. Your lordship may kindly see. there will be no displacement. But these persons will go to, as against that on-field vacancy of 44, these OBC persons will go to the
On the basis of merit.
exactly. Then your lordship may kindly see the next page. That means 8 OBC vacancies were there, 17 will go to the general category.
So 25 will come.
25 will come. And my name is serial number 9. Now they are saying only 2-3 persons can be added. If we will go by your version without touching that select list or without touching to the persons already joined, then still 65 persons in this way can be accommodated, my lord. And they are saying that what they are saying, why they are saying this, according to them, since we have not given the proper adequate representation of ex-servicemen in other category, as against these vacancies, now will again appoint the ex-servicemen against all those categories. You cannot. Now you are saying whatever already you did, that let it. And so far as these posts are lying vacant, you as per the specification you fill up with. List is with you. And you have already select list is there. We have been declared pass. But because of your lordship already observed that since cutoff mark we are below in the cutoff mark, we cannot. 37.5% is the cutoff mark so far as OBC is concerned. I have secured 37 mark. And in the end, this even if this
if they are really they transposed into the UR category, then 17 vacancies remained in the OBC.
Yes,
and then naturally the 17 you have to go 17 steps down. And if you go 17 steps down, then you
not
are
only 17, 8 on-field vacancy. That means 17 plus 8, 24. Then the OBC 24, 5 persons will be accommodated. This is the way. 44 persons in general.
No, I got you.
This is my humble submission.
You are for OBC.
I am for the OBC. My humble submission.
So
If you are trying to protect your...
You are will be more jealous. Because you are eating up 17 folks.
Yes.
Well, I am for the UR.
That's why I say you will be very jealous to you.
Well, I am for the UR.
This argument.
Yes, sir.
You are for 3.
I am for the 3 and I am appealing some AC candidates. With my Lord friend, I am appealing for the 3 AC candidates and 3 UR candidates. Here,
now we have, according to his submission, conflict now.
Now, we are also coming.
Conflict amongst your class.
My lord, we are also coming with that zone, Miller. If your lordship will hear me for a moment, I am showing that chart again. My lord, the total post advertised is 303. If your lordship will see their chart, Miller, this number of chart, first chart. For a moment, your lordship can see me. Out of 303 posts, 158 posts are earmarked for UR. Then 43 Miller SC, 66 Miller ST, 36 Miller for OBC. And our main challenge here is that they have given Miller the appointment to the USM, which is not earmarked here, Miller. That is the reservation they have exceeded more than Miller. No, Miller, I am coming. They are admitting Miller. How Miller the mistakes have been done by them.
Now he says that what to do.
Miller, if at all Miller 24.5% of the ESM have been adjusted in all the 3 categories, Miller. It lists Miller 74. So in the second list, your lordship can see Miller. All the 74 ESM candidates, they have been adjusted in the UR. They have not been adjusted in SC, ST and OBC. And Miller, in their counter affidavit, there's some that they have given their horizontal quota. And Miller, they have the ESM candidates, they have not been offered the marks relaxation and the age relaxation. It's horizontal quota. And if your lordship will see the cutoff mark, they have not given any marks relaxation. No age relaxation. In the counter affidavit they have submitted, Miller, the cutoff mark for ESM Miller is 31.5. And Miller, the cutoff mark for the UR is 42.5. But they are saying that with the horizontal reservation they have given. That has been the starting point of the case. Then the 74 posts have been deducted from the post year for the that is from 190. All the 70 posts that is filled up in ESC. Next, only 84 posts were offered to the UR. So out of 84 posts were offered Miller. If your lordship will see, they have joined Miller. 53 ASM candidates were joined. And Miller, now the 44 posts are lying vacant in the UR. That is admitted by them, Miller, 44 posts are lying vacant. And now Miller, my learned senior is saying that Miller, the cutoff mark is 39.5. If Miller, they will calculate in the same manner, Miller, it will be come down.
Then his argument will be more dangerous. And there will be many reserve category candidates who have secured higher marks than cutoff marks in the UR category. Sorry, that's the UR. They will be moved from there to UR again. They will eat up UR. Only
As against the.
They have rejected all the
on-field candidates we are asking.
Going by 39.5 and given a chart that these are the candidates who have occupied under these OBC categories actually have obtained or secured more than 39.5. So he says that let them be moved to UR. They should not be treated under the OBC. So 17%, so 17 vacancies will come in the OBC. 8 vacancies are already there, notified by them that they did not join them. So it takes 2, and then you appoint 25 candidates. Below those 17 candidates, go by 25, whoever comes appointed. That is his argument.
We are only here under 30%.
If you say this argument, then it will go further down. If it goes further down, then the 39.5 will also go down. And the candidate who is in OBC or in SC or in ST, if they secured higher than that mark, so they will automatically be moved on
Here we have
to UR. They will
all total minutes we are finding.
So UR will be squeezed.
Now, all total.
Any candidate?
Mother, all total minutes.
Is there in that category any person like that? More than 39.5?
More than 39.5, we don't have more than 39.5. That is why my London senior is saying that 3% are accounted to when they have calculated the figure 39.5. Only 3 petitions are there.
They are exercising for that they have simply restricted whatever the pattern of UR, OBC, SC, and ST is there. And then they have followed. He has taken a different rule. That no, you now re-exercise on this. Re-evaluate. Those who are there in the reserve category, they can move them into the UR. And then the vacancies would alter in the reserve category. The moment the vacancies in the reserve category alters, then it will include more people from the reserve category. And you are for UR, that's why he is saying.
Only 3% are here, Miller. But
Problem is
what for I am submitting, only 19% there, 65% lying vacant. And they are saying that 13, they are putting a cutoff mark now, 39.
Your case is that whoever have come to the court, please appoint everybody, lock, stock, and barrel.
No, we are coming with that zone, and you are admitting that several mistakes you have done.
All the red petitioners are
Yes.
below 65.
You have adjusted all the 70% ASN candidates in the UR category.
Why not?
The post were the total posts were 158. It reduced to 84 minutes because the ASN candidates who have been accounted in SC and OBC, they have been adjusted in the UR. So the UR post of UR from 158 to 84 only. So after that adjustment also 44 seats are still lying back. And in the SC Miller, the last time my logic senior was saying that all the posts are not available. And from this table we found that still Miller in SC 6 posts are lying vacant. In the ST Miller 7 posts are lying vacant. And the OBC Miller 8 seats are lying vacant. And in the UR Miller 44 seats are lying vacant. Total 65 posts Miller, they are saying that 65% lying vacant and only all the people are 19 men.
All the red petitioners.
Total red petitions are semi-fraudulous. Because when you have submitting before this in the procedural Millers, they have committed the fault. And we are fighting this litigation since 2015-16 minor. And in our writ application, where your lordship has admitted Look, party procedure we are suffering all.
I understand. You are justifying your argument on that particular motion of the live and let live.
And other things. In all their appointments period which has been given, there is a condition that your appointment is subject to the result of the present. Since because your lordship in the first instance directed that all the appointments are subject to the result. So they have not become permanent till now. They're also challenging your appointment when you have done something wrong.
He has admitted yes, there has been a.
And there is a proposal from your lordship side, my lords, you accommodate all the 19%, everything will be all right.
They are also showing that we are very considerate and we have taken the decision, we have thought of, we found 3 persons, we can accommodate 3 persons. He has come up with one innovative exercise. According to him, it will open more, the opportunity for those who is coming under the OBC category. So there will be more persons who may come. He is more concerned with his plan and who comes. So he is happy. Now your problem is because if his contention is accepted, then 3 of your clients may get an opportunity. Provided SC candidate is also moved in UR.
And regarding reservation, even you are saying.
The bottom line of the entire episode is that I am ready to forgo everything. Accommodate me, whatever the number is less, you accommodate, don't treat that as excessive.
Yes.
Or else they are admitting that
That's
this
the
judgment is correct.
Ethical substance theory.
And other thing, my lord, when they are saying that no age relaxation and mark relaxations have been given, my lord, it's admitted fact that they have given the reservation, marks reservation, and my lord, this age relaxation.
Yes. Whatever argument
That is the main thing. That 74 candidates, my lord, they are not given the horizontal reservation. Your lordship will give the chart. They have given the marks relaxation as well as the age relaxation. By saying that we have not given the marks relaxation, age relaxation, the document is there. It's there.
You don't have any argument. We have no argument. So they have also considered. Yes. You have also no argument.
No, already they have.
You are for
Manoj Khuntia.
okay.
My lord.
You are happy.
My lord.
At least from their stand, you are happy.
Still then they have not given issue of supplement.
Because of them, he is in position to give. He is ready to give.
We are not.
No, they are ready to give. Because of them,
They have not opposed us. They have not opposed us. Let them give.
They are opposing.
No, they are.
That why you are giving it to 3? Don't give it to 3. Give it to 190. I mean, other way they are opposing.
We all are selling in the same boat, man. Which now, we 90%. Now, their stance have been changed.
I think
now, 3% because earlier they were there, Miller. They have also not given the appointment at the first instance. During pendency, they have calculated a new theory that is 3% are coming with that journey. Otherwise, earlier we all were selling
The
the
difficulty is that because the interior decoration of all the boats are different. Maybe same thing, but interior decoration is different.
Yes. Different rooms.
Do it after that when you have very candid and very fair in this approach. It will not create precedent, but if they are 19 in number, think about it. Because his argument is also to be taken into account, and he is to some extent in accordance with the constitution-based decision of the Supreme Court. Switching over.
Yes, that's what I had here. This discussion about switching over. The switching over would be again detrimental to those three candidates. Otherwise, they now have pointed out.
I do not know. That's why I told.
I
told.
Because their adjustment also.
Yes.
Both are very-
I told that you are opening up such a floodgate. I do not know who will submerge into the water and who will be beneficiary.
That's what I'm pointing out. Now, suppose notionally all these OBC candidates are to be shifted to the UR category. From the UR category, third successful candidate will have to go out.
True.
That is the issue.
44 after.
One or two candidates will go out.
So only one OBC candidates are here, so we are not saying that those persons are sleeping in the slumber, they will get the chance. Because they have to now consider the availability of the petitioners here.
Well, the difficulty is the moment the UR posts are reduced or getting reduced, then the barrier would also be higher.
44 vacancies.
Yes, problem.
44 as against 44. One OBC will be adjusted there. Those persons are not coming to
17, he says.
As against that 44, that cutoff mark will come down, then 17 will go, Miller. I am not saying so far as the person, those who have already occupying the chair, Miller.
You are arguing, sir, that they have said that 39.5 I can go down. The moment you take that particular figure of 39.5, you immediately calculated it that certain OBC candidates have secured more than 39.5. So why they will remain and occupy the OBC post? They should move to a UR post on the merit.
As against 44, Miller. As against 44. They have calculated
44 minus 70.
Miller.
Then
Again, 27 persons will be accommodated from general category.
27
then 27
comes 27.
Miller.
Then the candidate 27 has to be considered on the basis of the UR merit. So
41.
36.
No, it goes to 41. Goes up.
No.
These two will go up.
No. Because they have calculated 44 seats, that's why they have arrived at 39.
Yes.
If they calculate 27, 39.5 barrier will go up.
Then
Go up.
Yes.
And the moment it goes up, the gentleman who has a smile standing behind you can always come and fight.
Two will go, one will get.
That
because he's 39.5.
I think Miller did that. No,
he may not be affected.
40 is
39.
No, my first client is 39.
39.
Is 40.
He will go.
Then 40 also might go.
The
40 also might go. Two will go, one will get.
The Lordship has segregated my case. So I.
That is a way of praying before Lordship.
No, I am not segregating.
Yes.
It is. I am saying the way he argues.
Yes,
if it is accepted.
Those are the merit of the case.
Since the never ending
situation. Since because the procedure, entire procedure, in terms of seniors argument,
Additional Solicitor General. Now this situation has come.
What can be?
What do you think the working? You have 65 posts, 19 registrars are there. You know the concept of visitors. You know the concept of it will not be treated as a precedent.
Yeah.
And will not be cited. Only thing is that whether they will, because it will link. Yes. Now the moment we accept this, again exercise, they will come with one solution. Ultimately, nobody is gainer. And they are talking about 74 posts subject to the result of interim order.
Yes.
But the single bench has not upset their appointment.
Yeah, fine.
So their argument is not tenable in that way. As the writ court says that their appointments are bad, cancelled, I would have understood. But the writ court ultimate order
Protects them.
so interim order merged into a final order. So their contention is not correct, but they are 19 in number. Altogether.
One problem would be go to one.
I understand, but that the one exercise has to be undertaken in this reform.
Very good. One thing is emotional exercise. Other one is by looking at the marks of what is 20, 25, 26 and of no stretch of imagination, no point of time they would have made just because they have come to court. That will be very, very dangerous.
No, I appreciate it. I appreciate it.
That is only.
But the difficulty is that will invite a further exercise to be undertaken. Because his contention cannot be ruled out.
Absolutely.
Absolutely in consonance with the law.
Absolutely, absolutely. Because OBC has to be first given priority under the UR.
Yes.
We'll shift it then.
On the basis of merit.
Yes, on the basis of the merit, that has to be done. The moment it is done,
Why not OBC? Even a SC and
yes,
SC also on the result.
by shifting everyone. Now, I think other three, which are otherwise qualified, they might lose.
That's true.
Yes,
That is what we are thinking.
yes, they might lose.
That is what troubles us.
Two are certain to lose at the cost of one.
No, I take you very frank. Recent trend of the Supreme Court is that they are very, I would say, averse to the concept of creation of a supernumerary post. Yes. Not propagating those the 1970s or 80s concept, the era has changed now. He must be aware of.
Yes.
So that is a shift that we have seen. As done. So I think it's a very difficult situation. But secondly, they will not make parties. All those candidates who have been appointed, they will not make parties.
Yes. In a representative character, some of them has been.
Or representative. Order one who made and compliance was there. When you talk about a representative character, then order one who made has been compliant.
They are not let them participate.
But let's see,
In my case, 8 persons I have made. In my case, 8 persons I have made participate.
that is what I am talking about. That situation is like that. So how to combat this amicable solution?
Yes.
Impressing upon them to consider.
We are also paying for blooded senior blood. Let them consider all the cases in the 65 posts are like that.
Let them to give the offer the offer. February 10, 2025.
No seniority like it can't be done. That's like this place before it. Cannot come.
No, we are not claiming
We are also
financial
not claiming
benefit.
that
All
money
of
also-
us. Finally,
No, even your position in the seniority, according to the single way, that you will be placed there and they will be below you. This
Can interfere with that.
date of appointment is a very important factor. Notional benefit is only for the purpose of counting of the years of
past
service.
service.
For the purpose of pension, if you retire, if there is a pensionary benefit. So it's a qualifying service, continuous qualifying
Yes, yes, yes.
service for completion.
Then some, the retirement.
This is what I'm saying.
Yeah.
If it is not, then everything is to be open first. Okay. Because his contention cannot be.
Absolutely, absolutely. What I can suggest, subject to the approval of the Honorable Court and this one.
No, have a talk.
Yes.
With the authorities. I'm
Yes.
telling you now, this is the situation.
Yes.
If this is there, it will again open a Pandora
Yes,
box. Again.
Yes.
And you do not know, it will be a never-ending litigation.
Yes.
It will be a never-ending litigation. How to put a quitters?
Quite us.
How to put a one which will not be taken as a precedent, no doubt about it.
We'll have it on third, by the time I'll come back, because other matter on the same data.
Or to have the matter disposed of by one way or another. I think 142 will be the best possible way.
As your lordship said, it will be a never ending process. So, at 10 years.
Last 10 years we are waiting.
10 years already gone.
For the restricted sweetener which was given by him, now bitter for many. Now understood.
Your lordship, can you indicate that? So that's it.
What?
But that's
On this.
No, no.
They will come with
No.
complete proposal.
Everything out of the way, we will not impose anything on them. We can't say anything. It is just out of way the observation has come, which has no scientific. It should not be perceived as binding one. It is just to ponder upon the situation. It's nothing more than that.
What best can be done with the situation, will tell you. Interest of
Ponder upon the situation. Nothing more. You can't impose.
Come back on third. Then, on third, I'll come back, because I have to be, for another matter on third, I'll be here. I'll be.
Third.
2 p.m. 2 p.m.
Congratulations.
You have done a good exercise.
Yes. I appreciate it. This was, used all his legal acumen and as
You have done a good exercise.
yes.
Those 3 cases. Those 3 cases.
That's fine. But interchangeable positions.
Item
I don't know.
22.
Your lordship, item number 22, my lord. To my learned senior has already made a mention for tomorrow. My learned senior is in this taken court number 1.
Yes, you what?
Tomorrow, your lordship, my learned senior has made a mention.
Give way to others.
Item 23.
Where is lodge? So the case relates to the sexual harassment inside educational institution, the college notes.
This was the other side. And where is the order of 6?
There are
No, 6-5.
6 maybe 215. At page 215.
Who was appearing?
Then Mr. J.K. Mr. was appearing for OP number 3, the contesting opposite party. And M.M. Bandlana DG. Then I filed a petition before the honorable single judge.
background, sir. I am more on because there is one Supreme Court judgment is hovering in my mind. I'm just trying to find out that how far we can. So that is what I am just trying. So this is the order of 6/5/2025, where you said that he does not want to press the review.
Yes.
And that was disposed of as not pressed.
Yes, boss.
Then an application was made.
Yes, boss.
What? Seeing that you never said so.
Yes, boss.
Huh? Where is the petition?
220. 220.
220. Yes, yes, boss. That I. Then I put it first the order dated 6/5/2025. Then paragraph 3 was abstracted.
Yes.
Paragraph 2
Yes,
was
fine. Was there any affidavit filed from the other side?
No, so other side, I filed one affidavit, and ultimately your last can see.
No. Against this application, page 220, you will file an application.
Yes, ma'am.
On 11/6/2025.
Yes, ma'am.
Whether any affidavit from the other side was filed?
Yes, boss. One affidavit was filed, but that was ignored by the
opposition.
So that affidavit has been ignored by the
Sir, please try to understand.
I beg your
Any count, that is the whole problem with me because I am more conversant with the word affidavit than the counter affidavit. I simply mean any counter affidavit to your application was invited or filed.
Invited and filed.
Where is the counter affidavit to this application of
Recalling
recalling the order?
Yes, because that has been ignored by the honorable signature, that has not been filed.
This any objection and affidavit has been filed by the opponents or not?
Where is that?
But that has not been annexed.
Why?
No, because that has been ignored. No, sir, I beg pardon. Because that has been ignored.
That is false.
Sir, do you know the importance of reading? Do you realize you have stated a very startling facts? How the other side has dealt with, we must know. As he accepted or denied.
You're also very correct on that.
So where is that opposition? I mean the objection or a counter affidavit?
That is for a moment. You also can paste the 219 page. Just a moment. Your also is correct. I pardon. 219.
Yes.
The last line you also can see. Actually, I stand objection to the IA filed before the registry is hereby ignored. So for that reason, I have not filed. That is my opposition to lordship. But I can file it.
Sir, you are challenging an order which according to you is absolutely wrong, and you will not file. And you should have taken a plea that how the court can ignore the counter.
No, that plea I have was taken in my petition. Well, there is an error apparent on record
I do not know, sir, review petition, and this IA, still I'm really confused. I think.
Let me be clear.
No, you will not create a more confusion. You are referring an order of 8/7/2025.
Yes.
This IA 236 was there.
Right.
This IA 236.
Yes.
Was in respect of the modification of the or in effect recalling the updated. This the opposition or the the objection was filed to this IA 236 or 27. Give me a copy.
The copy was sought in the courtroom.
Mr. J.K. Misra, 2. J.K. Misra, 2. Yes, I know. Plus, I humbly submit. On the
Mobile number.
mobile number, plus I can get the mobile number. Yes, yes, I'll. Yes. Plus, may I humbly pray, plus, this matter will be called tomorrow along with that WPC so that he will appear before your lordship. At the fast case, this is a very serious case, plus. And for no, for
Very serious means you do not know where it may head.
because
We could understand why the official was not.
no, plus, I humbly prayed before my lord because of there was that arrangement was couple. So there I regret.
You are a seasoned and a veteran professional. You know the law. You know the law.
Plus, I wanted this matter not to carry before lordship in an appeal. I tried my best, but I wanted to settle. I mean, to get the matter redressed before his lordship. And also on that, on the last occasion, on 8/7/2025, when this document was filed in the courtroom, I went to. I regretted. I even open court regretted, and thereafter his lordship has ignored. Lordship can ignore this affidavit. This affidavit has been written in a. I think the client has written the even the. And
well imagine that what has happened and what is in.
yes, yes. I'm also deeply obliged to my Lord Honorable Justice Satpathy because his lordship has ignored it.
Because not to take on record.
Yes, boss. I prayed for that and my Lord agreed with me.
Well, given notice.
Just now?
Monday,
Yes,
they read this matter.
Yes. Three. Yes. Sir, copy. But I am
number, WP number.
application number 26710 by 2024.
Yeah.
Yes, that is it.
Single bench or division bench case?
Sir, a single bench. Single bench.
How can we take up?
No. I am not saying, but for your lordship's kind perusal.
Just see that he probably filed an application for contempt. The service will be affected upon him when we given a contempt. And this matter will only appeal. He says along with that matter that it appear. Again, single bench matter.
For your lordship kind perusal. I am not saying that your lordship can take it up.
Just say that he is already filed an application, it will be listed along with, so he will appear.
Yeah.
So how can a single bench matter be listed before the? We are directing that since he is already filed and representing the opposite party number such and such, service will be affected upon him. By you, to secure the puzzles, we are keeping this matter on Monday.
Tuesday, my humble. I will not be available on Monday.
It's not very healthy for the legal profession.
No. Right.
It should not be
Right.
an affidavit in such manner.
Yes.
Yes.
Item 24.
What my judgment, my judgment, my brother was not.
Your Lordship sitting with Justice K. Arma.
Yeah, that's.
Yesterday it was there.
Yes,
I think was a joke.
yes.
I have already taken a view.
Or my humble submission here that this case can find to the facts of this case only. Because in this case,
In every case, there cannot be a similarity of the facts. Can you give me two cases which has an identical and similar facts? Never.
here,
But the principal's ratio has to be decided, and we say that a separate copy of the resolution is not.
and my lord, here, a copy of the resolution was sent.
No, it was not. It was not.
That is what I'm placing paragraph 13 of that judgment. Paragraph 13. Thirteen, 14, 15, I am placing that way. The dispute hinges on the resolution taken in the meeting of the 1/3 members who have signed the requisition. Whether such resolution was adopted on a date when the meeting was convened or subsequent there.
Sir, it is, have to be read in paragraph 3.
Yes, paragraph 1, your lordship may kindly see. The
Paragraph 3 also.
yes, madam, paragraph 1.
That is the order of the single bench. I am talking about fact which you said. Paragraph 3.
Yes, right. Yes, madam. Amidst the pendency of such decision for disqualification of some of members, the appellant received a notice, letter dated 11th November 24, issued by the sub-collector, which contained the letter requisition dated 20th October 24, issued by some of the ward members, along with the resolution alleged to have been passed on 22nd October 24, to the effect that a special meeting would be held on 30th November. So I'm showing the Panchayat Conference Hall consideration of agenda. So here a resolution was also given, but the date was different. It was claimed that on 20th, but it was signed on 22nd, and that will further clarified from paragraph 13. From paragraph 13. The 15 is this issue. Yes. The dispute hinges on the resolution taken in the meeting of the 1/3 members who have signed the requisition, whether such resolution was adopted on a date when the meeting was convened or subsequent thereto. It is evident from the letter issued to the district collectors Bhavanipatna Kalahandi that the same is signed by all the requisitionists and the proposed resolution is attached on the next page, though it bears a date 22nd October 24. But the said letter was issued on 20th October 24, signed by 11 members of the said Gram Panchayat with a clear note that the copy of resolution is attached in the next page and the same is being forwarded to the district collector. It is sought to be contended by the appellant. Now, though it bears a date that is 22nd October 24 at the top corner of the right-hand side, but it has no bearing to the date of issuance of the said notice, which would further be corroborated by the fact that the resolution was signed on 22nd October 24. We are unable to accede to such submission for the simple reason that admittedly the meeting was held on 20th October 24 and the resolution was taken, which would be corroborated by a subsequent letter annexed to the petition as Annexure 3. It is conceivable that the resolution would be taken on a posterior date and not on the date of convening the meeting. Even the appellant has not made out any case that the meeting was not held on 20th or 24 but on a subsequent date, and therefore it is improbable that the meeting, which was admittedly on 20th October 24, ended without taking any resolution. There is no fetter in signing the resolution on a posterior date, as it simply ratifies and signifies the decision taken on the date of the meeting, and therefore it does not invalidate the notice or the resolution under section 24 of the Act. The notice is accompanied by a resolution which fulfills the conditions enshrined in the statutory provision, and such compliance has to be interpreted in a pragmatic manner.
we are unable to comprehend the contention of the appellant that the expression copy of the resolution appearing in the aforementioned statutory provision is to be interpreted in a sense that it would be a part of annexure to the notice or requisition. In other words, such resolution must be recorded in a separate piece of paper and to accompany along with the notice. The purpose of the resolution having taken in the meeting to be accompanied with the copy of the notice is to be made known to all the members that the meeting would be held and the decision shall be made on the agenda or the decision taken by the requisitionist in an earlier meeting pertaining to a no confidence against the Sarpanch. Such procedure is to ensure the fairness, transparency, and meaningful discussions to be made on the proposed agenda of the resolution, and none of the members should be put on surprise on the date of such meeting. The purpose is laudable as the authority convening the meeting has to ensure not only the strict compliance thereof, but also to secure equal participation of the members. I have already read. Then, my lord, the next few lines. We don't go by this, sir. Tell me your claim. My lord, in the notice, only a copy of the requisition was sent. That is telltale on the face of that notice itself. That is what I have annexed as Annexure 1 to the writ petition. That is in Odia. And the English translation I have given in this writ appeal. Page 14 of the writ appeal. You will see. Page 14. Yes. And the original in Odia is there in the writ petition Annexure 1. Yes. It doesn't matter. Yes. Yes, madam. It is. What is the difficulty? Only the word resolution is not here. Yes, ma'am. That's the problem. Yes, ma'am. That is already there with the counter. Why you did not file a rejoinder? No, in the counter they say that it is not required. No, sir. They have said that it is accompanying. The resolution was taken, and then after the requisition, everything was sent. No, my lord, that is. I'm sorry, my lord. My brother has brought to my notice. Please read paragraph 5 of the counter. Well, that is the submission of the intervener. What is the submission to me? The interveners counter. Paragraph number 5. Counter paragraph 5. Sorry. 5 is opposite party number 2. Who is open? Opposite party number is sub-collector. So, you find the counter. Yes, ma'am. Paragraph 5. Yes. No, it's not the people. It's the people. Excuse me, I'm so nice. This one.
Paragraph 5 I am placing.
First, let him place paragraph first.
That in reply to the amendments made in paragraph 1 and 2 of the writ petition, it is humbly submitted that the petitioner admits that 10 out of 14 ward members have submitted a requisition on 8/10/24 enclosing the resolution dated 28/9/24 expressing their want of no confidence motion against the petitioner. Yes, my lord, they have submitted to the sub-collector.
So resolution also.
They have submitted to the sub-collector. But a copy of the resolution was given to me. That is what it is not a fact that the notice does not disclose the attachment of the proposed resolution.
So this is what you wanted, that it must notice must
accompany the requisition as well as the resolution.
It says that it is not correct because it was done.
That was sent to the sub-collector. Two stages. They will submit to the sub-collector, then sub-collector will give notice to me, to all the ward members. And both the requisition and the resolution must accompany the both. And my humble submission, in the notice itself speaks that only a requisition was sent. Annexure 1, your lordship. It never discloses that a copy of the resolution was given. And my humble submission, it cannot be improved in the counter. Because the document will speak for itself.
Paragraph 15 of that judgment rendered by your lordship, it deals with that.
And my lord, again in the subparagraph, page 4 of the counter affidavit, your lordship may kindly see. Borado Patra.
Borada Patra is something different.
Yes, Borado Patra.
This is phonetics.
And your lordship may kindly see from Odia dictionary. Yes, Borado means requisition.
Indian translated copy. So, you will have it. It is a. What do That's all, sir. Anything more?
Another division bench decision of this court of 2014, which says that the twin tests must be complied with. Requisition and resolution. In that case, requisition was not given, but a resolution was sent along with the no confidence motion notice, and this court passed it. That it must accompany both. Paragraph 8. Paragraph 8, 9, 10. From the above, it is amply clear
that the members of the panchayat have resolved to move the no confidence motion against the sarpanch by their meeting dated 28/5/14, and the sub-collector in his notice dated 11/6/14 issued under section 24 of the act accompanied the resolution of the members of the panchayat dated 28/5/14. The mandate of the provisions contained in section 24(2)(a) and C are two. As per section 24(2)(a), the requirement is that no meeting shall be convened except on a requisition signed by 1/3 of the total membership of the Gram Panchayat, along with a copy of the resolution proposed to be moved. And the second requirement is that the subdivisional officer on receipt of such requisition shall fix the date, hour, and place of such meeting and give notice of the same to all the members holding the office on the date of such notice, along with a copy of the requisition and the proposed resolution at least 15 clear days before the date so fixed. The documents filed along with the petition as well as the writ appeal clearly established that the meeting was convened on 28/5/14, in which the members of the Gram Panchayat decided to bring no confidence motion against the Sarpanch on 30/5/14. The members of the Gram Panchayat submitted a requisition to the sub-divisional officer for bringing a no confidence motion against the Sarpanch, which was sent along with a copy of the resolution dated 28/5/14 proposed to be moved. But the sub-collector, upon receipt of the proposed resolution, fixed the date, hour, and place of meeting by issuing a notice dated 11/6/14, and while fixing the date, hour, and such meeting, giving notice to all the members, had only accompanied the resolution of the members of the Gram Panchayat dated 28/5/14, as clearly reflected in the documents via Annex of 3 to the writ appeal. We have heard the respective parties and gone through the materials produced before us, as well as the provisions relied on by the parties. Provisions of section 24(2)(c) of the Act makes it amply clear that though the sub-collector Khurda was required under the statute to issue notice of no confidence motion, accompanying therein a copy of the requisition and the proposed resolution, with notice of no confidence motion did not accompany the requisition. Thus, notice by Annex of 3 also suffers, being not in consonance with statutory requirements by section 24(2)(c) of the Act. In view of the above strong factual position, this court does not.
We are referring the matter to a larger bench.
You, before that, may submit one thing. Para 8, 9, what my learned friend submitted, doesn't go contrary to a lordship's judgment. Doesn't go contrary. Let me
It is only what I find is that there is a distinction so far as paragraph 10 is concerned. Everything is in tune and surreptitiously jump to paragraph 10 without any basis.
That's what my intention was to place.
Without any basis. So we wanted to have a departure therefrom.
Your lordship has observed requisition with an intent of the resolution. It must be communicated. It was there.
This is what suddenly jumped. Up to paragraph 9 was no difficulty. But suddenly paragraph 10.
Correct.
So we want to take a different view. Lot of argue. In course of the hearing,
There was an interim order in the writ petition.
Come, it will be constituted very soon, don't worry.
On the writ petition, there was an interim order.
Let us see. And come with a degree of purposive constructions, not the literal construction. Yes, that's.
Your lordship may say.
Mischief rules of hidden rules should also be taken into consideration. I just give you a broader aspect of this.
Some interim protection, your lordship may grant, or your lordship may say subject to result of the writ petition.
Anyhow, let us see. I have some administrative.
I think 30
orders
can be
matters
taken
to
from
come.
commerce.
Orders matters to come. Let us.